It's probably useful for me to say something about what I do. I come from an entirely different perspective, I think, than many of you, and maybe I'm just lowering expectations, but I'm an ERISA litigator and an ERISA defense-side class action litigator. My practice is limited to representing typically fiduciaries in very, very large litigations, challenging things like failed investments in 401k plans and the like. Think of me as the guy in the circus sort of cleaning up behind the elephant. People don't typically sort of talk to me at the front end when design issues arise, but I am rolled out once in a while sort of for the interim effect of what I've experienced in litigation. So I'm going to come from that perspective. I'm probably pivoting more off of John's paper and trying to drill home the point that there are things going on in the federal courts on a daily basis. And by the way, it's in this rarefied air, maybe I'm just trying to give you a whiff of the odor, sort of the world that I live in, again, the class action world. And I want to circle back, and some years ago, Olivia approached me. I was handling the first, and Unisys, the local based, once computer manufacturer, locally based, has been blessed, I suppose, with a series of class actions challenging the administration of their 401k plans. And so many years ago, I worked on a matter that came up. There was a conservatorship. John Garamendi, then the California Insurance Commissioner, and it was said at the time, looking to make a run for the State House, and pressed a conservatorship over executive life. It had junk bonds, a relationship with Michael Milken, but the Unisys savings plan had $110 million. It had a GIC fund, and by the way, and of course, we litigated whether or not the name of the fund, the word guaranteed investment contract, had particular meaning to the participants who were funneling their money into these funds. Now, the company is seized by the conservatorship. Plaintiffs' lawyers come out of the woodwork. They sue. After the Third Circuit, the district court here in Philadelphia dismissed the lawsuit, we went up to the Third Circuit, and the judgment in favor of Unisys was flipped. But in that interim period, I contributed to this book, Living with Defined Contribution Pensions, and I was sort of smarting about some things that had happened in the Court of Appeals, and I wrote at some length really about peculiar challenges and problems for 401k defined contribution fiduciaries. And I sort of need to sort of gently introduce a topic, and it's an issue I've spent, and those who know me, I've spent a good part of my career, some lawyers do this, hanging around one statutory provision of ERISA, and it's called 404C. And what 404C does, at least for defense lawyers, fiduciaries, and plan sponsors, it's the linchpin. And we say that what it does is it makes individual employee participants alone responsible for the choices they make related to their pension savings. And one can understand, at least we think, on my side, that this is a vast departure from the typical defined benefit plan where the plan sponsor ultimately is the guarantor of the benefit. And I guess if all hell breaks loose, the PBGC is there to kick in some money. But in my world, it's important to understand that the fight, the battle rages to this day over the meaning of this 10 sentences of the statute, and it has profound consequences for defined contribution plans going forward. So what happened was, and we get back on remand, it's called, from the Third Circuit, and we tried the case. And what the district court decided, and this was good news for the plan sponsor fiduciary community, is that the individual participants, and part of the fun of my work sometimes is there were a number of union representatives who held themselves out as class representatives, as plaintiffs, and we get to depose these people. And what these folks had done is they put together these tremendous files on a daily basis. The New York Daily News and the New York Post was writing an article a day talking about the slow decline of executive life. And the union was collecting this information and distributing it to almost all of the employee participants in the union plan, and in the entirety of Unisys. So we take their depositions and you get admissions like, yeah, I read that. Did you move your money out of that fund today, sir? No. Here's another article from the New York Times. It says, California Insurance Commissioner says conservatorship around the corner. This Michael Milken mess is about to collapse. Sir, you read this article? Yes, yes. Did you move your money? No. On and on it goes. This is the grist of litigation. This is my world. It's an ugly world. But we convince the judge and ultimately the United States Court of Appeals for the Third Circuit, and again, in part, hanging our hat on this little section of ERISA called 404C. Court agrees the participants have a responsibility for their own money, even if there's an allegation in the first instance that it was a fiduciary breach to select this stuff. And that's probably the most controversial aspect of the Third Circuit's ruling, and that issue, by the way, remains in play. More recently, in the 401k space, and something I was very much involved in, a law firm in St. Louis basically sued everybody, saying that investment management fees are too high and record-keeping fees are too high. I have the dubious distinction, I suppose, of representing ABB Corporation. And in my world, ABB, everybody bristles or stiffens. We tried one of these things, a class action that still is ongoing. We tried this thing, I guess, rough numbers and keep things moving and with little time. Maybe we lost $50 million, which was really, for me personally, a bad day in the career. It was not a lot of fun. By the way, these litigations are emotionally charged. What happened was, and Margaret, are you still here? She's in the back. Somebody who was with me at the trial in Kansas City, I had taken the deposition of one of the class representatives. What we do, we started calling them as adverse witnesses. You bring them in, you cross-examine them. This particular individual, we called up their lawyer, said we want him the next day. He goes into the plant in Kansas City and shoots a couple of his coworkers, and then it was thought by the United States Marshals that he was coming to the courthouse, and some thought coming for me because I was the one who had insisted on his deposition. But I tell this story, and unfortunately, or for better or for worse, he killed himself before he ever got close to the courthouse. But the point I'm trying to make is it's hard for me to convey to you people how these issues are emotional, and the promise of benefits to individual employees, it's hard to settle these cases. They see it as a trust relationship. They don't see it as something you can simply quantify in dollars and cents, and it is emotional, and these trials are just electric. And it's a fascinating experience, and maybe someday when I can distance myself from it, I'll write a killer book or something that sells a little better than this. By the way, if anybody brought their copy from '98, I'm happy to sign my chapter. It'd really be a first for me, if you're okay with that. But interestingly, in the run-up to the trial, we interposed this 404C defense. And by the way, the courts today are all over the place. The Department of Labor, they don't like this thing. The plaintiffs, the organized ERISA plaintiffs class action bar, they're fighting tooth and nail to sort of cut this thing back. And ultimately, someday, I think the Supreme Court has to resolve the law on this, which is all over the place. But in my world, or the way we saw it, you look at the prospectus given to each participant from which they can tell the costs associated with a particular option on the plan. And in a revenue sharing model, not to get too fancy, but the compensation to the record keeper, for example, is informed by individual participant asset allocation. And what we said to the judge, and really consistent with the Unisys ruling I mentioned a moment ago, was gee whiz, everybody knows what this is going to cost them, because really you're talking about mutual funds basically available to 401k participants, and if they want cheap funds, they can go one way. If they want to take on additional risk or pay for more exotic investment management, they can do that as well. And unfortunately, there's an instance where a court disagreed with it. No. You don't go there. So that went up on appeal, by the way, and the Eighth Circuit Court of Appeals just the other day, kind of, again, rough numbers, whacked the judgment down by 2/3, but remanded the case for more proceedings, assuming they don't grant somebody's rehearing petition. Again, this 404C, do we live in George W. Bush's mythical or elusive ownership society? That really is the issue. I got my head in the muck. I can't quite pause to figure it all out. You people do that. But I'm just telling you, the battle is raging in the court system over who bears the responsibility in defined contribution plans, and it does impact sponsors and fiduciaries who are personally liable for breaches. And sort of the magnitude, and I'll make this real fast, on the defined benefit front. And this is a great story, at least for me and my client, a happy ending for us. Weyerhaeuser, Seattle-based forestry products company, uses aggressively, confronted with all of the challenges that have been touched on here today, 2 minutes. Alternative investments, derivatives, hedge funds, private equity. They are a, dare I say, wild outlier and it's no secret, the General Accounting Office has been looking at the use of alternative investments in DB plans. Weyerhaeuser aggressively uses this stuff. To their credit, they've been killing it forever, 400 basis points above every relevant benchmark until 2008. Plan asset values go down 43%, lawsuit. Now, interestingly, in this world of defined benefit plan litigation, the Constitution comes into play. And there's a no harm, no foul rule. A federal district court has to have before it a case or controversy which includes a cognizable harm to the participants. And what we say, not surprisingly, the funded status, the asset values go up and down, the benefits get paid, and if, again, things go wrong, the company, Weyerhaeuser, which is wildly profitable, stands as guarantor of the benefit. But the plaintiffs sought $2.4 billion in damages, joined something like the 16 investment committee members as defendants. They were upset, and rightly so. That's a lot of money. Judge agreed with us that there was no case or controversy, kicked the case out. It went away. But maybe the takeaway here is, and again, DB plans are on the wane. In that circumstance, Weyerhaeuser, and again, very, very sophisticated investment management operation, they have what they call their strategy, capital S. And their belief is, if there are litigation or regulatory burdens, if they increase, they will freeze accruals, be done with it, just get the hell out of the business, because they don't need that kind of fiduciary responsibility. So, by the way, one thought that comes to my mind, the incentives here are all wrong, and I'm talking about, Kevin, raise your hand, ERISA's fee shifting provisions. Basically, if the plaintiffs win, they get their fees. And when you're talking about these big chunks of money, it can be a third. Defendants win, they can try to get their fees from the plaintiffs. Never, ever, ever happens. Courts just don't agree, even though the language in the statute is neutral. I tell you all this because, at least from my perspective, American courts, Congress should look at what's called the English rule at a time. Whoever loses pays the fees, and maybe we could create some better incentives against litigation here. Thanks for having me. Careful about out there. Otherwise, you'll run into someone like me who has to defend your deposition. And if you haven't been through that, it's a surreal experience. Thank you.